A seemingly violent charge against a police officer turned into a plea bargain rooted in a parental defense of a teenager. Gary Alexander Hickson was facing a charge of simple battery on a police officer in this Georgia court. The case began with the formal plea, but the outcome hinged on a powerful, unexpected explanation given by the defendant himself.
Negotiated plea, Your Honor.
Reginald Antonio Johnson.
Your Honor, I believe.
One second. Can you hear me now? Hello?
I can
like
hear
going
you.
in and out. Yeah, like I can't hear it now. I don't know if they can.
All right, can you hear me now?
Yes.
Yes.
All right, so Mr. Hickson, you're before the court on state of Georgia versus Jerry Alexander Hickson, 2026 CR 04394 for simple battery on a police officer. Ms. Tortorello is representing you from the law firm of Lister, Holt & Dennis. Ms. Tortorello, what does your client plead to the offense before the court?
No, Your Honor.
By entering a plea of nolo, Mr. Hickson, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. You understand all of these things, sir?
I do, Your Honor.
All right, factual basis recommendation, please.
Yes, Your Honor. On March 19th, 2026, at approximately 4:14 a.m., officers responded to 2311 Wallace Creek Trail, Jonesboro, Georgia, and that's in Clayton County, in reference to a domestic disturbance. Upon arrival, officers made contact with the victim, who stated that the police was called due to the defendant being heavily intoxicated and yelling threats throughout the house. The officers then made contact with the defendant. The officers observed a strong odor of alcohol coming from the defendant's breath. And as the officers were questioning about the defendant as to what occurred, he was being belligerent and yelling and speaking loudly, even after being told to lower his voice. The defendant repeatedly invaded the officer's personal space and had to be told multiple times by officers to step back. The defendant then approached one of the officers and struck him on the back of his vest with an open hand before exiting the residence. And then the officers decided to make an arrest. The state is recommending for count 1, 12 months to serve 10 days, credit for the time served. The balance will be probated for the defendant to pay a $300 fine, and then the balance can suspend.
Your Honor, our understanding.
Is the $300 fine required for a simple battery on a police officer or just battery?
I'm sorry, Your Honor.
Is the $300 fine required for a simple battery on a police officer or just a battery on a police officer?
Let me see. Yeah, it's in terms of the simple battery, $300 is not required, but it is a high and aggravated misdemeanor.
Okay.
A law enforcement officer.
All right, Ms. Tortorello, anything on behalf of Mr. Hickson?
Yes, Your Honor. Our understanding was that the balance was going to be suspended and he had a $300 fine. We were going to ask for him to have 60 days to pay that.
Okay,
we agreed to balance suspended. Thank you.
Yeah, Mr. Hickson, I don't know that this requires probation. I sent you to 12 months to serve 10 days credit for time served, and you'll have 30 days to pay the fine in the amount of $300, $444 with the surcharges. You said 60 days or 30 days?
60, Your Honor.
60 days in which to pay that amount. Mr. Hickson, it is infinitely easier and safer to be drunk in your home than drunk in public. So if you are intoxicated and you're outside of a safe space, and you come into contact with people, all kinds of things can happen to you. We clear?
Yes, Your Honor.
You can tell her your side if you want.
All right.
Can I?
Is there, yeah, tell me
I'm
whatever
about
you
to tell
need.
you, Mr. John, I don't want to hold you up, but with both my hands, I swear to tell you the whole truth. If you
Well,
just-
come to the red mic.
Okay, Your Honor. First of
Mhm.
all, nothing against the police, but I did not put my hands on the police. I swear, both of my hands swear to God I didn't. I caught my son smoking marijuana. I snapped on him.
How old is he?
He's 17. He's graduating Lovejoy. 17 years old. Caught smoking marijuana.
Okay.
I saw my own eyes. He got a blunt in one hand and a vape in the other hand. Yes,
When a defendant pleads guilty, they are waiving several fundamental rights, including the presumption of innocence and the right to a jury trial. This is a major decision because it means the state doesn't have to prove guilt beyond a reasonable doubt, as governed by the principles protecting defendants in court proceedings.
Double
exactly.
dosing?
Yeah. But Mr. Your Honor, I've been here since the 19th. He just got arrested for weed in Pensacola, Florida. The same thing. So when I saw him smoking marijuana that night in his car, I told him, because I knew he was smoking weed because I found the blunt paper in his room. I say, dude, you can't be doing that. I said, we just got him a car. I say, they're going to search your car. They find weed, they're going to tow your car. I saw him smoke. I went in his bedroom that night, Your Honor, honest to God, swear to God. I saw him, one hand with a blunt, the next with a vape. I stood by the kitchen door. When he came in the house, that's what I told him. I'm not going to curse on you because I respect you, Your Honor. But
That's
I told
okay.
him,
Mr. Hickson, you got a 17-year-old. I'm just gonna pray for you. The $300 fine will be suspended. You're free to go at this time.
God bless you, Your Honor. Thank you. Thank you. Okay.
Important. Graduating without a record is even more important. All right, next.
Samantha Orange.
All right, raise your right hand for me, ma'am. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right. Is this Miss Orange?
Yes, ma'am.
All right, Samantha Denise. Ms. Orange, you're before the court for a petition for revocation of probation. You were before this court on case 2022 CR 00525.
The factual basis presented by the prosecutor detailed the elements of the crime, which is the process where the state lays out exactly what happened to meet the legal definition of the offense. The court must ensure the defendant understands every right they are giving up before accepting that plea. The court ultimately accepted the plea, resulting in a sentence of 12 months to serve, with 10 days credited for time served. Furthermore, the judge suspended the $300 fine, allowing Mr. Hickson to be released from custody immediately. This decision reflected the judge's consideration of the mitigating factors presented by the defendant. While the law demands strict adherence to procedure, courts often balance legal standards with human context. This case shows that sometimes the narrative of why a crime occurred can influence the final, merciful outcome. Subscribe now to follow how these complex legal decisions play out in real life.